Hello, my name is Dominique and welcome to my presentation. Today I will be speaking on the topic of Six Nations land and development. Within this presentation, I will begin by discussing the history of the Six Nations land by going over the Haldeman Tract. Then I will focus on Six Nations land, specifically their land claims and purchases over the years. Then I will close by discussing the differing developmental processes both on and off reserve and the resulting effects on the Six Nations community. Beginning with history, the Haldeman Tract was the treaty which essentially founded the Six Nations community. The treaty entailed land granted by the Queen to the Iroquois who served the British side during the American Revolution. The decree was issued by the governor of the province of Quebec, Frederick Haldeman, on October 25, 1784. The area which was granted was actually chosen by the Six Nations Aboriginals. They wished to take possession and settle around the banks of the Grand River. The resulting territory is what is now known as the Six Nations of the Grand River, the largest First Nations reserve in Canada. The map shown here illustrates the original treaty granted to the Iroquois. The land was situated between Lakes Ontario, Erie, and Huron. Today, the land is much smaller and is bordered by the towns of Brantford, Hagersville, and Haldeman County. The shrinkage of their territory has been an ongoing issue for the Six Nations Reserve. Land claims disputes have become increasingly common for the community. These claims are presented to the Aboriginal Affairs and Northern Development Canada, now known as Indigenous and Northern Affairs Canada. Specifically, they are submitted to their specific claims department. There, they focus on Canada's obligation under historic treaties and the management of First Nations land and other assets. Between the years of 1980 and 1995, Six Nations of the Grand River submitted a total of 28 specific claims to this department. Due to the large influx of claims, negotiations between Six Nations, the Government of Canada, and the Province of Ontario commenced in April 2006. These negotiations began to address the multiple claims previously submitted, but was specifically commenced when the Douglas Creek Estates conflict arose. The Douglas Creek Estates conflict began in 2006 after a housing company named Henco Industries Limited began the construction of a housing development on Six Nations territory without the permission of the Indigenous community. The issue involved land situated on the outskirts of both the Six Nations Reserve and a small town called Caledonia. Specifically, land which had been granted to the Six Nations of the Grand River in 1784 under the Haldeman Tract Treaty I spoke about earlier. As a result of Henco's development, the Six Nations community band together to begin a protest which lasted for months and included the setup of a barricade blocking the road surrounding the land. Currently, the issue has not yet been resolved and the Douglas Creek Estates conflict is still in negotiation through the Indigenous and Northern Affairs Canada. For land claims issues such as the Douglas Creek Estates conflict, there are many parallels that can be drawn between it and colonialism. Though these situations are nowhere near the same caliber as the historic events which plagued the Indigenous community, there are still similarities present. For example, in the past, Aboriginal peoples were stripped of their traditional territories and restricted to the reserves we know today. Land claims issues are, to an extent, the same situation. Indigenous territories being taken away for uses which do not benefit the Indigenous community. Additionally, this is somewhat similar to the doctrine of discovery. The automatic assumption that claim can be placed on lands which are currently not in use, disregarding traditional treaties and arrangements. However, it is not always as simple. Traditional treaties are often disregarded because of the fact that they are not largely publicized or well known among the general population. As a result, in some situations, it is possible that lands are claimed accidentally due to lack of knowledge. This takes us to Six Nation land purchases. As I noted earlier, the Six Nations territory has decreased in significant size over the years due to land claims issues. As a consequence, the Six Nations community has had to dedicate finances to repurchase land in order to rebuild their land base and combat the historic disregard of treaties. As of today, the Six Nations community has repurchased land totaling approximately 1,024 acres in various locations surrounding the reserve, including the lot listed below on the slide. Lastly, I will be discussing the different developmental processes both on and off the Six Nations Reserve. There are two different land development processes within the Six Nations community: the Haudenosaunee Development Institute, or the HDI, and the Six Nations Elected Council. I'll begin with the Haudenosaunee Development Institute. Their practices are governed by the Haudenosaunee Confederacy Chiefs Council, or the HCCC, and they uphold the Six Nations traditional development processes. The HDI also has certain goals they strive to achieve within their developments. The first being the objective to uphold Haudenosaunee heritage and historical events, meaning that no developments can interfere with significant landmarks. The second goal is to ensure they maintain and follow their regulatory framework, which identifies, registers, and regulates development in compliance with regulatory obligations, primarily pertaining to the environment. Similarly to the HCCC, the HDI decide on development projects by consulting with the traditional chiefs of each clan family. Traditional chiefs act as representatives for their respective clans and are responsible for relaying the information regarding each project back to their clan families. The traditional chiefs will continue to consult until a decision is agreed to by consensus. However, there are some decisions which can be made independently, like a business. These decisions involve minor developments deemed necessary for the community. Moving on to the second development process, the Six Nations Elected Council. This is another example of colonialism affecting the Six Nations community. The elected council had to be introduced in order to act as a liaison to the federal government. Prior to its introduction, the HDI and the federal government's practices were incompatible and prevented any possible collaboration between the two parties. The Six Nations Elected Council is how the community receives government funding and how their relationship with the federal government is managed. Additionally, they are responsible for overseeing the community's core organizations, such as health services, economic development, and more. The way in which this developmental process functions is highly regulated by the federal government. Developments stemming from the Six Nations Elected Council are primarily government funded. Therefore, prior to any implementation, projects must be reviewed and approved by the federal government itself. Finally, development outside of the Six Nations Reserve. Off-reserve, development primarily takes place on privately owned land and, as a result, development can occur at a faster rate. Involving privately owned land means that the only requirement for development is to purchase the lot of land in question. Once it is under an individual's ownership, they can decide what they'd like to do with it, subject to the receipt of proper permits if necessary. Due to the close proximity, outside developments have both positive and negative effects on the Six Nations Reserve. The positive effects have to do with the increase in potential commercial opportunities. For example, recently a new housing development named Empire Avalon commenced in Haldimand County, a location which borders the Six Nations Reserve. As a result of this new subdivision, the population of Haldimand County is expected to increase slightly. Because of this increase and the housing development's close radius to the Six Nations Reserve, it is anticipated that businesses located on the reserve will benefit in terms of the Empire Avalon occupants becoming new customers. The negative effects have to do with how fast developments off-reserve can occur. Due to the rapidity of the process, it is likely that mistakes can arise. An example of this is the Douglas Creek Estates conflict I discussed earlier. In this situation, the development was commenced so fast that there was no opportunity for the Six Nations community to object or even point out the fact that the land in question was a part of their territory. As a result, the protests began, further extending the dispute. If the process of development were slowed immensely and more regulatory checks regarding land claims were implemented, land claims mistakes would be mitigated. This concludes my presentation on Six Nations land and development. I would like to thank you very much for listening.